SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Which is a very important concept for your upcoming prelims examination of May 2025. We have already discussed the concept of state under article number 12. We have discussed citizenship, union and its laws. We have discussed about preamble. Now we are going to come up with a new important topic to understand what do we mean by law. See, fundamental rights are there. If these fundamental rights are infringed either by the private individual or by the state, you have the remedy to approach court, okay, under article 32 in Supreme Court and under article 226 to High Court. Now most of the fundamental rights are given against the state and some of them are also given against the private citizens. You must have heard that the state must not discriminate on the basis of religion, race, caste, sex, place of birth. And how does the state discriminate? State discriminates by two methods. Either when it is executing the policy as an executor, okay, or when it is making the policy in the parliament. So we have already understood the concept of state in the previous class, that the state involves the center government, the parliament and the executive, the state government, the state legislative assembly and the executive, which involves the chief minister, council of ministers and other things, the local authorities and other authorities. These four important pillars come under the definition of state. So state through legislation or through execution of the policy or execution of the law or the provisions of the law can infringe or curtail the fundamental rights of the citizen. Okay, so it can also do it through law. It can also do it through law. Think about a situation where parliament has passed the law which is discriminating on the basis of religion, race, caste, sex, place of birth, descent, place of origin, or not providing equal opportunity in front of the law, equality before law or equal protection of law, okay, or giving titles to people, which is creating kind of inequality in the society, not only on the meritorious ground but on other grounds based on their birth or their religion, the things which are abolished under article 18. So state through law can infringe the fundamental rights of the citizen, and that is why we are studying the concept of law, and that is the reason why law has been defined under article 13 of the constitution. So fundamental rights in our constitution under part 3 starts from article number 12 and continue till article number 35. Okay, article number 12 defines state and article number 13 defines law, and from article 14 to 18, that is right to equality, then right to freedom, then right to life and personal liberty, and so on and so forth. Okay, so coming to the next slide, article 13. Why this article is important? Why it has great value in the Constitution of India? Because article 13 in a way which defines law, definition of law is only one part of article 13. There are more elements of article 13 than only the definition of law. So article 13 in one or the other way establishes the supremacy of the constitution over all the other laws. We will see that. It establishes the supremacy of the constitution. It establishes the supremacy of the fundamental rights in specific and the constitution in general over all the other laws made in India. Supremacy of constitution is established over all the other laws by article 13. We will see how. Now when we say all the other laws in India, what could be they? Any law which is passed by the parliament. New laws, three important laws, BNS, BNSS have came, Bharatiya Saksh Samhita, Bharatiya Nyaya Suraksha Samhita, Bharatiya Nyaya Samhita, IPC, CRPC, all kind of law you can think about, even the personal laws of different religion, of different community, the income tax law, the laws related to transfer of property, the laws related to land and acquisition of land, any kind of law, ONGC law, LIC law, all kind of law which are made in India, okay, are under the constitution, has to work according to the constitution, and none of those law in any way, shape or form can infringe the fundamental rights. Hence, Article 13 establishes the supremacy of fundamental rights, the supremacy of the Constitution of India over all the other laws in India. Okay, how does it do it? Read this line. Laws inconsistent with or in derogation of the fundamental rights shall be void. Means any law made by the parliament, if are infringing the fundamental rights of the citizens, will be declared as void. Hence, whatever written in the constitution is more important than written in any other law. Okay, I hope you understood this. Now, in a nutshell, this is Article 13. There are 1, 2, 3, 3A, 3B, 4 clauses, and there is a 4th clause as well. We will study that also. So there are 4 clauses under article number 4. We will come to that one by one. So article number 13, clause number 1, if you see, it says that laws in force, all the law which are prevalent in India and were made before the commencement of the constitution. Now what is the date of the commencement of the constitution? 26th of January 1950. So all the law which were made by the authorities, the legal authorities, the parliamentary authorities before the commencement of the constitution, if any of those law infringe the fundamental rights, curtail the fundamental rights, they will be considered as void. Now, does the whole law is considered as null and void, or only the part which is inconsistent? It is always the part which is inconsistent. For example, this is the whole law and only 2 provisions, only this 2 or 3 provisions are contravening against the fundamental right, then only this much portion is void and the whole law will work. Okay, this is called as the doctrine of severability, that you sever, काट देना. आप उस legislation का, उस law का वो part काट देते हो जो fundamental right के खिलाफ जा रहा है, बाकी law वैसे ही चलता है. But if in this exercise you kill the very purpose or the soul of that law, then the whole law has to go, because the supremacy of the fundamental right has to be maintained. Okay? If the important provision of that law is infringing the fundamental right, and by removing that important provision you kill the soul or the purpose of this legislation, then the whole law is scrapped. The whole law is declared as null and void. But if only a small provision of the law is infringing the fundamental right, then that part, that little provision of the law is declared void and the rest of the law works as it is. So, okay, we think in our mind that all the laws in India which are now running were made after the constitution was made. No, that's not the thing. Although constitution was adopted, enacted on 26th of November 1949 and was enforced on 26th of January 1950, but there were many laws in India which were working since the old age, because customs are also there, usages are also there. Along with it, the Britishers have came and made many laws before the independence of the country, before the commencement of the constitution. Even they were working. Motor Vehicle Act, Indian Penal Code, all these are pre-constitutional era laws. Even the personal laws such as Shariat Act of 1937 okay, which was very much prevalent and was running and was executed after the independence, after the commencement of the constitution. Okay, so all the law in force. Now see, this law in force is defined here, clause 3. Law in force are those laws which were passed or made by legislature other than competent authority in the territory of India before the commencement of the constitution. So there are two kind of law. 26th of January 1950, laws made before this date and laws made after this date. Okay, so law in force were laws which were made before this date. That's clause number 2. The state shall not make any law. Now, the first clause is all about the laws which were made before the commencement of the constitution. Clause 2 is all about the laws which are made after the commencement of the constitution, or even in the present day. This particular clause is telling the state that you should not make any law which are inconsistent, which takes away or abridges the rights conferred by this part. This part simply means part number 3 of the constitution, means the fundamental right. And any law made in contravention to this clause shall to the extent of contravention be void. Here also, to the extent of such inconsistency. What does this mean? The doctrine of severability. To the extent of such inconsistency, only a part is removed if that part is infringing the fundamental right. Here also, to the extent of contravention, that simply means only the part will be removed which is contravening or taking away or abridging the fundamental right of the citizen, not the whole law. And if by removing that part, the soul and the purpose of the law is dead, then the whole law is scrapped. I hope you understood. Now, why we assign this meaning to Article 13 as the definition of law is because of clause number 3. Now you see subclause A, it defines law. It says that law includes, it has an inclusive definition. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, usage in the territory of India, having the force of law. So all of these are included in the definition of law. If Parliament passes an ordinance, State Legislative Assembly passes an ordinance, it also have the force of law. Okay, notifications, rules, regulations, because any of these elements can infringe the fundamental rights of the citizen. Let's say an act was passed by the Parliament. Now, in order to implement that act, several rules are also passed. Rules are also made. Now, if act is not infringing the fundamental right, but the implementation of that act through rules is infringing the fundamental rights, then the rules are void according to clause 2 of the constitution, clause 2 of the article 13 of the constitution. So I hope you are getting the logic behind it. When the law is defined in an inclusive definition, it includes all these things, the ordinances, orders, bylaws, rules, regulation. Okay, and law in force, we have already seen what does it mean. Before the commencement of constitution, all the laws which were there. Also, it is important to understand one important doctrine, the doctrine of eclipse. Every law which was made before the commencement of the constitution, if it infringes the fundamental right, is declared void. But that particular act or the particular law or legislation or bylaw, notification, whatever it may be, is not dead. It only gets eclipsed by the fundamental right. Once you remove that eclipse, once you remove the provision of the fundamental right, it comes to life. It is not dead, it is only dormant. Okay, whereas the laws which are made after the commencement of the constitution, and if it is infringing the fundamental right or some provision of that law is infringing the fundamental right, it is declared dead, it is declared void altogether. Void ab initio means void from the starting. But such is not the case with the laws in force, means laws made before the commencement of the constitution. They are not void ab initio, means they are not declared void from the beginning. There are several reasons for that, why they are eclipsed and not dead, why they are just dormant and not dead, because some legal authority must have made it. So because of that legal continuation, it is important that these laws must not be declared as dead, but only dormant, eclipsed by the fundamental right. Also, these laws were made by competent legal authorities, parliament, or it can be the British Parliament or any other Indian Parliament when it was made before the commencement of the constitution, although it was dominated by the British people. But to respect those legal authorities, these laws are not declared as dead but rather dormant. One more important thing is there, that if you declared these laws dead, they have prospective effect, not the retrospective effect. For example, Shariat law. In 2017, in one of the judgments of the Supreme Court, the clause of Shariat Act of 1937, under which talaq-e-biddat or triple talaq was executed, was removed, was declared as null and void, was declared as not according to the fundamental right or the Constitution of India. It was just declared void ab initio. So what would have happened? The Shariat Act and the provision of biddat, talaq-e-biddat, the provision of triple talaq, is now not dead but only dormant. It is eclipsed. It is only eclipsed by the fundamental right. And if you remove this provision of fundamental right, the provision of the original act of 1937 will come into life. This is how the doctrine of eclipse work. But these are all prospective in nature. For example, all the marriages, all the divorces which happened or which occurred before the commencement of the constitution under talaq-e-biddat, they cannot be restored now, because the judgment is prospective in nature, not retrospective in nature. It does not remedy whatever has happened earlier, but only looks forward towards the future, that from now onwards such a such thing will be there or such a such thing will happen. But it does not changes anything at the back date, or there will be chaos. Think about how many things would have changed if talaq-e-biddat or triple talaq is declared as unconstitutional, and all the divorces which have happened under that particular clause of the Shariat Act gets restored. There will be chaos everywhere. So Article 13 have prospective effect, not retrospective effect. Article 13 also gives power to the judiciary for judicial review. Any act which is inconsistent, where do you go? Who picks up that law? Who does that adjudication? It is the judiciary. Judiciary looks which part of the particular law, bylaw, ordinance, notification, custom, anything, which provision of that particular act is going against the fundamental right of the citizen. So it is the judiciary which is getting the power of judicial review under Article 13 of the Constitution. I hope you have understood this. So now let us come to the fourth clause, which is very important. It was not there in the original Constitution, but was inserted by an amendment act in 1971, the 24th Constitutional Amendment Act of 1971. Why was it done? Let us just understand the timeline. Article 13 gives immense amount of power of judicial review to the judiciary, reducing the power of Parliament to make law, because Parliament can make law. It can amend the constitution and do whatever it wants with law making and the policy making in the country, because parliament has been chosen by the people. So it is the will of the people which is behind the working of the parliament. The base of the power, the source of the power of the parliament are people who has voted them in the parliament. That is the reason why they are making law there, because they have been chosen by the people. Okay, now what happens with time? This question has came, is amendment a law? If you see this slide again and if you focus on the definition of law, you will see ordinance, order, bylaw, rules, regulations, notifications, customs, usage, but there is no use of the word amendment. Now this word amendment was not used here, it was omitted deliberately, or the constitution makers forgot to insert this word. But later on it became a controversy that if any amendment is made by the parliament, can it be considered law? Okay, so parliament, if parliament wants to change something in the constitution through an amendment, if it is considered as law, then that amendment must respect the fundamental rights. And if it does not respects the fundamental rights or takes away or abridges the fundamental right, becomes inconsistent with the fundamental right, then that particular amendment will be declared as void. That is a restriction or a limitation on the power of the parliament. Okay, but the word amendment is not used here. That simply means that any amendment done by the parliament will not be considered as law under this clause number 3 of article number 13, and hence the parliament has been given immense amount of power to amend the constitution as it likes without even paying attention to the fundamental rights. It can also take away some of the fundamental right if it wants. This was the position in the initial years of the commencement of the constitution, but this question have came up in front of the judiciary very initially. In 1951, Shankari Prasad case, this question was in front of the judiciary, whether amendment is included in the definition of law or not. The judiciary was new, the lawmakers were very famous, important personalities in India. Nobody can even think that the parliament at that point in time in 1951, which is the new parliament filled with, studded with superstars like Pandit Jawaharlal Nehru and other important people, nobody can even think that they may bring an amendment which can abridge the fundamental right or takes away the fundamental right of people. Hence, in Shankari Prasad case, the court has ruled that amendment cannot be considered as a law. So amendment is not a law. That simply means parliament has the power to amend the constitution as it likes. Even if the fundamental rights are abridged, it is okay, because there is no bar or no limitation on the power of the parliament to amend the constitution. And the same position was also there in the Sajjan Singh case in 1965. The judiciary took the same stance that amendment is not law in both the cases, in 1951 and in 1965, in Shankari Prasad case and in Sajjan Singh case. But then came the Golaknath case. It was a very important case, a case of 1967, where Supreme Court has overturned its earlier judgments in Shankari Prasad case and Sajjan Singh case, declaring amendment as a part of law. Okay, now amendment is declared as law. That simply means any amendment which is done by the parliament will be under the definition of law. What does this means? That any amendment done by the parliament cannot take away or abridge the fundamental rights of the citizens of India. It is limiting This particular case is limiting the power of the parliament to amend the constitution. That now before amending the constitution, the parliament has to think that we should not make any law or policy which abridges the fundamental rights of the citizens. So this is a limiting power, and when you limit the power of somebody, they don't like it. Okay, it's a simple thing. But in a constitution driven country, in a country where there is rule of law, the powers cannot be arbitrary. There has to be checks and balances everywhere. No organ of the state can have immense amount of power. There has to be checks and balances everywhere. Executive's power is checked by the parliament, and the parliament's power is checked by the judiciary. Judiciary also checks the power of the executive. Okay. But in 1971, through 24th Amendment Act, clause number 4 was inserted in Article 13 of the Constitution, and clause number 3 was inserted in Article 368 of the Constitution. What it has declared? That any amendment made by the Parliament under Article 368 will not be affected by Article 13. That simply means through this amendment, the Constitution has reached to its previous position that amendment is not a law. It has given back the power to the Parliament to amend the Constitution as it wants without thinking much about the fundamental rights. While making a policy, if some of the fundamental rights are abridged, it's okay. Why? Because clause number 4 clearly says that any changes or any amendment made under the Constitutional Amendment Acts by the Parliament under Article 368 will not be covered under Article number 13, will be outside the scope of Article 13. Hence, the power of the Parliament to amend the Constitution as it wants was restored. Then again, this case reached, and this question came in front of the judiciary in 1973 in the Keshwananda Bharti case. Very important case. Very important case. Okay. It has declared one of the important judgment, bringing up this basic structure doctrine in the Constitution of India, rarely seen anywhere in the world. Not even the greatest of the and the oldest of the democracies have this concept of basic structure, but India have, which helps a lot in balancing the powers of different organs of the government, especially limiting the power of the Parliament and the power of the government, the power of the executive. Also, truly implementing the important concept of constitutionalism, on the basis of which all the constitutions of the world has been made, that the limited government concept. The power of the Parliament, the power of the state has to be limited for the liberty of the citizens. This particular judgment and the basic structure doctrine is at the basis of it. Okay. Now, when this question came in front of the judiciary again in 1973 in the Keshwananda Bharti case, whether an amendment is considered or has to be considered a law or not, what did it do? It has upholded the 24th Constitutional Amendment Act. That simply means judiciary have said that it is okay, no problem, कोई बात नहीं. आपने clause 4 डाला आर्टिकल 13 में, आपने कहा कि पार्लियामेंट की जो पावर है अमेंड करने की, इट इज एब्सोल्यूट, इट कैन अमेंड एनीथिंग इट वांट्स. ओके, इफ यू मेक a constitutional amendment act under article 368 and you don't want article 13 to look over you, it's okay, no problem. We uphold the insertion of clause 4 in article 13 of the Constitution by 24th Amendment Act. But while making laws and policies, the Parliament has to adhere to the basic structure of the constitution, and this basic structure of the constitution should not be reduced, taken away, abridged or disturbed. That simply means you can enrich the constitution, but you cannot abridge the constitution, you cannot take away a part of it when it comes to the basic structure. Although the judiciary has not defined what is basic structure, but everybody knew through several judgments of the judiciary, it was almost in a way declared what does it mean by the basic structure of the constitution. For example, the contents of the preamble, sovereign, socialist, democratic republic, all those words cannot be taken away. India is a secular country, India is a socialist country, although these two words were added later on. So again the thing, you can enrich the constitution but you cannot abridge the constitution, the basic structure of the constitution. Parliamentary form of government. The concept of federalism, which is enshrined in the constitution, article 246, the three important lists, the council of state and the power given to it, all these are the basic structure of the constitution. This must not be changed by any amendment. So before, it was a master stroke. Before, there was bar on the power of the parliament, and the bar was called the fundamental rights, that no changes can be made in the parliament, no changes can be made through amendment by the parliament, because if any change is made which are against or abridges the fundamental right, it will be void. But now, because of the basic structure, this limitation has grown bigger. That simply means anything, any amendment brought by the parliament which abridges the basic structure of the constitution will be declared as void. Now, fundamental rights are also the part of basic structure. Earlier it was this fundamental right. While amending the constitution, the parliament has to take care of the fundamental rights. Now it has to take care of the basic structure of the constitution. Fundamental rights are also the part of this basic structure. Directive principles are also the part of the basic structure. Parliamentary form of government, federal provisions in the constitution, okay, then Panchayati Raj, municipality, all the important structure of the constitution, all the important pillars of the constitution can be declared under the definition of basic structure, and the parliament cannot amend it. I hope you have understood this important concept of what is law through this video, and how this particular question whether the amendment can be considered as law is evolved in India. We have seen the judiciary and the parliament coming face to face in order to grab the power, and how the master stroke of judiciary has brought this basic structure doctrine, creating a level playing field and checks and balances in all the organs of the government. So this is the concept class we will be indulging in every thrice a week, 3 times in a week. And thank you very much for joining me in this class. We've already covered preamble, union and its territories, citizenship, state, and now law. Thank you very much. We'll meet in the next class. By that time, till that time, thank you very much. Have a nice day. Jai Hind.